Duke, and I'm going to call you that for the purpose of the interview because I've known you well enough.
Fine.
Can you tell me how you receive your instructions for drafting statutes? Most of us get our instructions from clients in private practice, but there must be a number of ways that you derive your instructions, and what are they?
Well, you're quite right, Bob. There are a number of ways, many ways. So one can't be categorical in one's answer. But the general way to get started on a government measure, let's limit it to that field for the moment, is to receive a telephone call from a minister or perhaps a deputy minister and say, we're thinking of introducing some legislation on a particular subject.
This could be with any department.
Could be with any department of the government. It could be the prime minister. It could be anyone at a policy level. We've decided to do such and such a thing. Please think about it. There'll be a meeting tomorrow morning at 9 o'clock to discuss it.
Just like that, no warning.
No warning at all. But the warning is you've got overnight to put the pieces together and consider the general subject.
Did they reduce this type of request to writing and are more explicit later on?
Sometimes. Sometimes. They never, I should say, they never get more explicit later on, no. But the first gun might be a letter, a memorandum. Memorandum from, say, the minister
right.
To the Legislative Council. We have decided to introduce legislation along these lines. Please think it over, and there'll be a meeting tomorrow morning, or some such. So when you arrive at the meeting, at least you have your thoughts together in the particular area of operation. You know that the general area of the subject. So you sit down at, say, across the table. There may be the minister, there may be his deputy, there may be some division heads. The people that are knowledgeable in that area, in that department, will probably be there.
And this is so it really starts with oral discussion, strange enough.
It very frequently starts with an oral discussion of the general subject, yes.
Is there any, does a secretary take notes at this kind of a meeting? Or
no.
Does anybody
Council may well take notes.
Right. Do you have outside counsel that might attend?
Not likely, not at that stage.
I see.
Following the meeting, the Legislative Council will go back to his own office and probably cut off phones and bar the door and sit down and think about it.
Have they had, at any time during this process you're describing, had an opportunity to prepare even a semi-draft or a rough outline at all?
No,
not at all.
It's just ideas.
Ideas, I see.
Very often it's perfectly simple.
So it's truly part of the thinking stage. It's all thinking.
It's all thinking at this stage.
I see.
On the other hand, it may be very complex. Something that you, in the practice of law, dealing with clients, don't have. We have constitutional problems to think about.
Right.
Have we, as a provincial legislature, power, authority, to do what the government proposes to do?
This might come up, for example, with succession duty legislation.
It might come up in any area. And believe it or not, as you know, after well over 100 years now of operation under our British North America Act, there are very large gray areas where one makes a guess as to whether the power is in Ottawa or in Toronto.
So in the background all the time, although you've got these instructions, you must keep this constitutional aspect in focus at all points.
Very much so. Very much so. And it may be that the area is so gray that you feel it's your duty to advise the government that they're on very thin ice.
Right.
And then it's up to them to make a political decision whether or not they wish to take the risk.
That's one other point that had occurred to me, that at this point, would you be affecting policy at all? Or would you always be a recipient of policy? Do you actually say, now, wait a minute, you shouldn't go quite in that area, but move over here?
Certainly, I consider it the function of counsel to advise the government, and as best he may, whoever it may be, as to the desirability of perhaps another approach from the one they're taking. At any rate, it's his duty, I think, and I certainly followed this throughout my life, that you give the government or whoever the best advice you can and fight for what you think is the best way of doing it.
And you're drawing on all your legal training, of course, for this purpose.
Exactly, and all your experience and skills, if you will.
Well, then once...
Excuse me, then once the government or once the minister makes a decision on the policy, then you forget your personal views, you've fought the battle, and whatever the policy decision is, whether you like it or don't like it, then you get right on the bandwagon and support it 100% and proceed in that direction. Those are instructions.
Well, now, in what you've told me so far, is there anything that we can extract or take from that process that would be of help to a private practitioner in the preparation of other legal documents?
Sure, I think so. Principally, think about it. Do your thought process before you start to operate.
Well, now, on that thinking process you're describing, this is the part that my Dickerson I mentioned concentrates on so much. Do you think this is something that's not paid enough attention to, or do you think it's do you think people spend too long at that before they get down to work, or what's your...
I don't want to be critical of the practicing profession in Ontario. I have no right to be, but nevertheless, I think that many practitioners are so busy. They turn from one thing immediately to another, and they just don't have time.
True.
To develop the thought process. And that's true also of parliamentary draftsmen very often, where they have no time in which to properly think the project through.
Well, do you canvass these departments then a good deal ahead of time for their legislation, as to say, well, if you don't want it all coming in 1 week or something like that?
We do that annually, and perhaps too much, but without results. It never works. Human beings are human beings in Parliament and outside Parliament, even in the profession of law. And you get fellows that are naturally on time, the early birds, and they come along, and then you get the fellow that comes along in due course, as we say. Then you get the fellows just by nature late. And perhaps that's a pretty good way, because we don't hit the peaks.
You mean that a major statute that would apply all over the province of Ontario and last for 50 years could be drafted in something like a couple of days?
Might be less.
Less?
Might be. And it might be a dandy, too.
That applies in private practice as well. Sometimes if you are forced, for instance, a client's going down to Florida, he wants a will prepared, he's flying down, he's a little worried. And sometimes you can put your best thoughts in short order in a document of that kind. But I assume the same might be true then in this field.
That's perfectly right, yes. It's the same thing. You have a factor, and let's say, let's put it in proper focus, an important factor, and that is the relevant importance of the document that you are instructed to draw for a client, and that is you can't spend $100 worth of time on a $10 item.
Right.
It just doesn't add up. Well, government draftsmen don't have that problem. You know, it doesn't...
Time may be of the essence,
doesn't come in.
but nevertheless, you've still got to put your best thoughts into it. It's going to last for quite a while. You don't, when you're drafting, you're not contemplating having it amended. You're drafting so far as possible to have it unamended, unless it's affected by policy.
You hope so. You hope so.
Now, this outline that's slowly evolving, this is the process that Reed Dickerson in the States is trying to identify. And I know it's hard to pin down, but can you give us any thoughts on the form of the outline that emerges, or can you say there's any particular form that emerges from your concepts? For instance, would you block, I guess I probably should be saying, do you block out a statute
yes.
ahead of time?
I think the answer to that is yes, we do. If it's a work of any consequence, you know, of any proportions.
For instance, the one thing that occurs to me is that there is a section in the Business Corporations Act dealing with dividends. Now, Did it just happen to appear there in that, I've forgotten just the part, but say it was the middle part of the act? Is this decided early in the process where dividends should be dealt with in the sequence?
Oh, I would think it, in that particular example that you give, the Business Corporations Act, the dividends, that fits into a very natural spot. It just automatically goes there. There's no great thinking necessary to arrive at the answer.
Is that true of many of the structures that you have? For
Very
instance, how do you
sure.
figure out the seniority of groupings in the, in documents, I call it classes, but you must have groups of thoughts, and obviously in the statutes, I think, again, the Business Corporations Act is entitled shareholders, I think, under one part, and dividends under another. These groups, how do you get around to establishing those?
Well, you start out with your best thinking, and you lay down a bunch of headings, let's say, on a blank piece of paper. Shareholders, dividends, this and that, inside trading, so on.
As many
Up and
generic
down the
headings
line.
as you can
Yes,
establish.
the subject matters that you're going to legislate upon.
Right.
And that's merely a start.
Well,
Then you begin to really work it around, work it up, if you will.
Well, once you have
Change
this,
it.
supposing we have
Excuse me, Bob.
Sorry.
The process is one of continual change.
it's an open end of
Both
line.
the mental, open end, yes. Both the mental aspect of it and the paper aspect of it. It's a constant development, a constant revision going on
At all levels,
process,
then.
at all levels.
From the beginning.
You're never finished.
It's like a bit of a whirlwind. You're always involved in
Back when you're at the end of the line and you pick up the statute book and say, there it is, and you look at it and you say, heavens, why didn't they have another hour on that?
Now, in the writing stages, once you start, once these concepts have evolved, what is the first step in the writing stage that you would take, apart from grabbing a pencil and a pad? Or is that the first step?
I guess that's the first. I don't know anything ahead of that in the writing
There's nothing,
stage.
you start at section 1, or 1 in brackets, or whatever it is.
No, you start ahead of the section 1. You start with a long title, assuming you're writing a new act.
Now, what about this
You
long
design
title?
you design a long title that is focuses right in on the target, what you're trying to do, and you do that in as few words as you can. If you can do it in 6 words, fine. But getting back to the point of your question on preambles, I personally am against preambles. I think that they're more likely to cause trouble than to do any good. If the act is sufficient, is adequate, it will tell the story. You don't need a preamble to lay down the scenes, to fix the scenery. If there's a variation between the story as told in the preamble and in the body of the substantive part of the act, you know, which is right.
That had occurred to me just when you were talking.
Which governs.
Yes.
And so on. It can be a source of trouble, and most of the time we're successful, or have been successful in Ontario, for example, and most of the other Canadian jurisdictions in avoiding preambles. Sometimes, for one reason or another, the government will want a preamble on a statute to point up the political implications of it, or to get marks, if you will. But we'll listen to, take advice and drop the idea and let the act stand, the substantive provisions of the act stand on their own feet. Fine. There are exceptions to that. As you know, the Human Rights Code has a preamble.
That I wasn't aware of that, no.
There was a lot of nice talk from the United Nations Charter and so on, and the Constitution of the United States, and a lot of very pleasant phraseology that I must say looks very well on an illuminated, colored reproduction of the code, framed and hanging on a wall in some appropriate setting. It's very effective to have this done in Old English script and so on. You see.
Gothic script.
Gothic script. It's fine, but let's say we're better off without them, in my opinion.
Well, then, actually, I suppose in Ontario, too, we overcome part of that by having explanatory notes in the first reading of a bill. I find that when a new bill is being introduced, some of the sections are summarized for the benefit of the members of Parliament, some of whom are lawyers, some aren't.
Yes.
And this, I find, is as good as anything else. And those side notes disappear eventually and are never...
Explanatory notes.
Explanatory notes, not side notes. The side notes will remain, but the explanatory notes. And here, I think this is just perhaps for quick scanning. I don't think you're not setting them up as anything completely definitive, but they do perhaps replace the preamble or do a better job because they're tied in with the individual section numbers.
Well, yes, the explanatory notes go along with the bill through its early stages in passage through the House.
How long do they stay in? At what stage
They
are
usually
they?
come off on the third reading printing.
Oh, the third reading, I see.
The final printing of the bill in the House. They come off, and then they stay off. But you must remember that they form no part of the bill, and they cannot or should not be referred to by judges, by courts, in interpreting the statute.
Have they been referred to at all in cases? Do you know?
Well, there's been attempts made, and perhaps they've been looked at, let's say, unofficially.
Right.
And quite, I think the law on this point is completely sound.
What is that?
That they should not be referred to.
That's in...
To gather the intent.
Would Craze on statute law would verify this sort of approach?
Sure, though that's the law of the land.
That
yes.
is the law, I see.
Yes. And as I say, quite properly so, because very often the explanatory note is written early on in the drafting process, and through stress and lack of time, the bill gets changed, even in the final minutes before introduction, maybe. Right. And the explanatory note is overlooked, or there's no time to bring it into line with the statute, the body of the act. So it can be wrong, or you might be painting a picture for the benefit of the members of the House.
So amendment can take place, of course, obviously, in the House. It has. I mean, we all read about this in the paper, where amendments have been proposed by an opposition and some have been adopted.
Yes.
And for political reasons, whatever they are.
Yes.
And so this poll rating process then really is, as you say, is in a state of flux from the beginning of the rating process as well down to the finish of the
Oh, you're never finished.
rating and printing
Never
process.
finished until the governor signs it.
So there's no, perhaps it's not as clear-cut as in documents, that it's more in flux than documents, from what I can make out. Usually at some point, I would say in documents, you finally establish some draft that is a reasonable framework, although probably so for a statute too.
Your observation is quite correct, Bob. Perhaps the reason for that is that you have many more minds bearing upon a bill in a legislature than you do a document between a lawyer and a client.
Well, then, if this process is in a state of flux, both in the thinking stages and in the rating stages from what you've described then, and going through all these processes, there really doesn't seem to me any possibility of it being made definitive in the sense you couldn't computerize it, could you?
Well, in my opinion, no. It's pretty hard to look into the future, the computer age. What will come next year or 50 years from now, take a courageous fellow to make a guess.
Now, you were at Queen's University, you
But,
say you lectured there, and that's the very source of a lot of the computer information.
Yes, they're doing some good work mostly in storage and retrieval
Yes,
of statute law and case law and that sort of thing. Where to get your answers quickly, it seems to be the game now, but to use electronic devices to think and prepare bills, which is a thinking process. I can't see it.
You can't see it,
I can't see it, no.
Yeah, the best computer is up here.
Yeah, because everyone's different.
I see.
Certainly there are set provisions common to most statutes, such as in a commencement section, the enabling formula,
Right.
common to all statutes. Same as there are in deeds or mortgages. There are
yes.
common clauses.
standard.
For the most part, standard stuff. And, of course, that could be pulled out of a computer system and a printout available instantaneously. So might save a little time, I don't know. But after all, we haven't got to the point where, at least as far as I am aware, where computers are able to think.
That's really what we're saying.
Original thought.
That's what we're saying. If you get them to the point where they can think, they'd be, I don't know, some other kind of being, but at this point...
You and I'd be out of business.
Might be a good idea. But at any rate, this computerization, for retrieval, though, it would be satisfactory. Well, if it's good for retrieval, then would you put statutes in a retrieval system? Would this be appropriate to put? Or because of the...
It might be.
Annual amendments, I wonder if this would make it too difficult, because you're taking slots out of a statute here and there, and it looks like a peppering.
We're just piling more in the machine all the time, each year.
It might be able just to knock out Section 5 and reinsert some new Section 5. Once, of course, you've done all the thinking processes. This type of automatic replacement.
Oh yeah, that's been
might
done.
well
That's
be
been done
engineered.
for years.
It has
Yes.
it? I see. Is it being done in Ontario, or
Queens are doing it.
what about federally?
Well, they're in the Queens project.
Oh, I see. Right.
It's Queens Department of Justice project, joint. It's a joint effort.
Well, if you have a request for one of these statutes in your office and you do delegate it to someone else, and you're asking him to apply all his thinking processes to it, is there any way, how does he learn how to do this from you? I mean, we were just mentioning a computer doesn't think what we think. How do we teach someone else how to think?
He does it by doing it. He learns by doing it.
By the apprenticeship method?
By the apprenticeship method. I don't know any better, and I doubt if we'll ever evolve a better. We can provide him with better tools, such as your book, such as Reed Dickerson's book, such as Elmer Dreger's book. And there are half a dozen good books. And speaking of books, let's not overlook Sir Ernest Gower's Complete Plain Words.
I'll agree with that.
That is a must, it seems to me, for everybody that has any drafting of any kind to do.
He seems
Whether
to
it be a business letter or a complicated bond mortgage.
He's done some research there, which I haven't been able to find in other volumes. He seems to, for instance, the word same, he says it was used as a pronoun some 400 years ago. He seems to establish that from looking at some sources, but how he got at these sources, I don't know.
He's just terrific, and that book should be must-reading and rereading for people in the bar admission course.
I
It's
see.
just, to me, it's fundamental, it's basic, it's essential.
Well, now,
But getting back to the point, I think the apprentice system, learning by doing it and sitting at a more experienced fellow's elbow and learning and going with him on his from day to day, following him in his work, drafting the odd section here and there in the piece, and gaining experience that way. And then going back to his own room with his own little project to start with, and coming in asking questions. That is the way to learn the business of drafting, it seems to me.
well, what I gather from what you're saying, you sort of launch him, give him a push out on the sea, and then from then on, he's sort of on his own, and he
Except you're there looking over his shoulder at all times.
I see.
To be helpful and also to be a watchdog.
Well, this type of person in your department, would he have to have some profound knowledge of grammar and...
No, I think not. I don't think, I think as you bring out in your book, Bob, that the super knowledge of the rules of grammar aren't essential to being a good legal draftsman. And I quite concur in that view. I think a facility with words is a very happy thing.
Mm-hmm.
An understanding, a feeling for words.
But that's something different.
That's something quite different.
Mm-hmm. Grammar, I get the feeling at times that it's something that you're using labels and you're trying to dissect sentences, and that is not what drafting is all about. We're not tearing down or ripping apart. We're building up. And when you're building up, you tend to, you're not particularly looking at those rules. I agree with, of course, you can't violate some basic fundamental rule. Obviously, it's got to make sense to us, but most of these patterns, from what I've been reading, have been, are in our heads at about 8 years of age or something like that. We instinctively have them.
Well, yes, I think that if one follows the ordinary rules of grammar or syntax in drafting legal documents, the product will be better than if you don't. It's bound to be. If we get back to our old friend George Coode and his book and his analysis of phraseology and how to construct.
Back in 1843.
Yeah, well, 130 years ago or something.
It's amazing.
He wrote the book, and it's still gospel.
Still live, right?
It's still good reading.
Mm-hmm.
Well, if you take a lesson from him, and I think he teaches a good lesson, there's help to arrange your minor clauses in a reasonable order, having them close to the word they are naturally attached to.
You don't, what about the place of
That sort of thing.
colloquialisms or this sort of thing?
No, I don't think statutes or legal documents of any kind is the place for colloquial English.
They'll exclude that much of it, although you should appreciate, perhaps.
Oh, of course, because that's the way you communicate orally with your principal.
Right. Well, now, in all these things that you've been talking to me about, you've obviously concentrated wholly in this area and are more definitive than almost any person that we know of in Canada. And yet, some people still say drafting can't be a specialty, but you have been a specialist all your life, and now the Law Society is making an announcement that they're going to recognize specialties.
Yes.
And I think one of the categories that they've missed out on is legislative drafting. And yet that is probably the longest specialty, or perhaps one of the longest outside of perhaps the criminal bar. And
well, of course, they've just started on this project.
Oh, yes,
they're just out of the gate.
Right.
Where it'll end, no one knows. And it may well be, you may be quite correct that drafting of legal documents will, sometime or other, become a specialty. One thing, perhaps, in my view, might be against it, and that is there's so few of us. We can hardly form a class, so to speak, that's worth
identifying with the word specialty, except apart from legislative drafting.
I can see where corporation lawyers and criminal lawyers and so on, trust officers and so on, there are enough of them around to make a group, to have a specialty, and to live their own lives in their own camp, so to speak. But when it comes, certainly in parliamentary draftsmen, there are only a handful in Canada, and there never will be any more.
Apart from time, which we have discussed, what would you say that would be the chief problems of a legislative draftsman?
Well,
would it be identifying the concepts, or would you think, would these be found, for example, more in the thinking stages or in the writing stages?
well, they crop up at any stage, even after you fall through. A problem will suddenly...
Have you ever got to the end of an act and had to sort of roll it up into a ball and throw it in the basket and start over?
Sure I have.
After having gone through all that?
Sure I have. But the next effort is a lot easier than the first one. But sure, you talk to your opposite numbers in other jurisdictions, you get draw their brains, if you will. And I should perhaps make this point, Bob, that often I've called lawyers downtown in the town here or in other cities that I suspect or know have some special knowledge on a point that I'm interested in and doubtful about, and in other words, need some help. Call them up, and invariably, without exception, in my 36, 7 years of experience in this field, I've never had a cold reception or even a cool reception.
Thanks very much, Duke, for joining us today, and I think all your comments are very worthwhile, and I hope we all take them to heart. Thank you.
It's been a pleasure.